Well, let's move on to the annual lecture portion of the Stair Society. And these are, this talk, I think, is going to be, a fascinating one. The topic is Witchcraft and Scots Law. And our speaker this year is Julian Goodare, who will be, I think, well known to many of you. He is now Professor Emeritus at the University of Edinburgh. His recent publications include editions of David Chalmers' Compendium of the Laws of Scotland, and for the keen-eyed, that was an earlier volume for the Stair Society in 2023, and also the Scottish Witchcraft Trials for the Scottish History Society. And again, I think that's a publication this year. He is a director of the online survey of Scottish witchcraft. Having tested that, that has an interactive map. And if you have a particular affiliation with a location, you can click and find whether that location has the tragic history of having a witchcraft trial or not. My husband is from Gatehouse of Fleet. Happily, that village was only founded after this period, but where he went to the academy in Kakubri, unhappily not. And in fact, there were several there, so I had fun looking at that. Now, before he also has, I think, an extensive historical, an extensive list of his prior publications. I think one can find that on the website. I won't work through that, but I think it's going to be an engaging talk. And can I therefore invite you to welcome Professor Julian Goodare in the usual way? Thank you.
Yes, thank you, Sarah. And thank you to the Council of the Society for doing me the honour of inviting me to address you. It is certainly an honour, and I'm very conscious of some distinguished predecessors, and I'll be coming back to that, in fact. And thank you to all of you for coming and taking part in this event this morning. So, yeah, witchcraft and Scots law. If you see something that doesn't look right, even if you're not on a train, yeah, what are you going to do about it? What is somebody else going to do? How are you going to inform the authorities? And who's going to decide whether it might perhaps involve a crime? You see what I'm getting at here? A lot of the history of criminal law concerns the courtroom drama itself. But a lot of the stuff to do with criminal law is before people go into the courtroom. And I'll be saying something about what I'm going to be calling the arc of investigation and prosecution, and trying to sort of trace some patterns. I'll begin by talking about the evidence that was used in witchcraft trials. The title doesn't give any indication of period, but I will be talking about the period in which witchcraft was a statutory criminal offence punishable by death. And I'll then be looking at the procedures and the courts that actually processed those alleged witches. And begin with a little sort of commercial break. Sarah's already mentioned it, but yeah, earlier this year, from a rival outfit, the Scottish History Society, got over 600 pages of legal sources. So yeah. Yeah. So yeah, witches and witchcraft. And what does it mean? And I think there's many people, and there's a temptation many people seem to want to really just stare at that word, and eventually the essential meaning, the ultimate definition of a witch, this is what it really means. You just stare at it for long enough. But yeah, it's not really like that. And one of the reasons it's not really like that is that there isn't actually just one word anyway. And witchcraft, there's a whole lot of different ideas of what this, and I'm not going to go through all this, right? But there's a whole range of things. There's a menu or a syndrome or something. And that is just in the English language. And of course, a lot of the jurists we have to deal with are looking at Latin terms. Again, I'm not going to unpack all of that, but that one, even more clearly than the English one, reminds us that there's a gendered aspect to this, which I'm afraid I'm going to have to set on one side. But if you're on trial for your life in a criminal court, there is a single categorical decision that has to be made. And so perhaps we do have to bring back, are you or are you not a witch? Have you or have you not committed witchcraft? One of the ways that some people think we can work out how this happened is by staring not just at one word, but 200 words. And this is the notorious Scottish Witchcraft Act, all of it. And it is very interesting, and I published an entire scholarly article about it, but, quick summary for present purposes. It doesn't actually define witchcraft. It does, the title is, and then witchcrafts, which might suggest that it's a crime that you commit on a specific occasion rather than being a witch. And there is this witchcraft, sorcery, and necromancy. I mean, sorcery is pretty much clearly a synonym for witchcraft. Necromancy, maybe we can set on one side because it's a bit specialized. But yeah, the long and the short of it is that the Scottish Witchcraft Act does not actually tell the courts how you can work out who is or is not a witch, so they have to make it up as they go along. And so what do they do? When I'm discussing or thinking about witchcraft as people understand it in this period, I tend to think that there's different levels of witchcraft. And the demonological level this is the sort of intellectual one, the idea that witches have a relationship with the devil, and the demonic pact, the idea that the witch has sold their soul to the devil. That is the key legal idea at this level. And then for ordinary folk, it's about bewitchment, it's about harm done on a specific occasion. So it's not about being a witch, it's about committing acts of witchcraft. I'm going to use the word malefice for that. And, below that, there's a whole range of stories and ideas about witchcraft, and indeed experience, because, some people, when they're hauled in and asked to confess to witchcraft, they go things like, well, I didn't meet the devil, but I did meet the Queen of the Fairies. Well, that do. Yeah, all sorts of strange things are coming out in those confessions. I don't really want to get into that, though. And in court, it's just the first two. And in my numbers there, I've just inverted those first two. And the malefice is sort of where it begins. It sort of begins among the neighbours. But the courts seem to be more often interested in the demonic pact. And you can't separate these systematically because a given case will often have more than one, and exactly which one is more important than which other one, you can't always work out. But let's unpack this in a bit more detail. And first of all, the evidence for malefice, the evidence for actual harm being committed by magic or witchcraft. What evidence is the courts using? And overwhelmingly, it's the first one. It's on these bullet points. It's the people who say that they've been bewitched, and they testify either in the locality and you get written testimony. Sometimes they actually appear in court, but it's the testimony of actual people who have experienced bewitchment. And in the much longer version of this, I might discuss whether they are witnesses or informers or this kind of stuff that, some lawyers can argue about these kinds of things. But testimony about bewitchment. Sometimes when people are being interrogated about suspicion of witchcraft, they will be asked, what harm did you commit? I think that's kind of subsidiary. I'm going to come back to confessions in a minute. And then You see other things in ditties such as habit and repute, which again, neighbours, you sometimes see neighbours testifying this person is by habit and repute of which this person has been known to be a witch, etc. Which is related to this person bewitched me, but not necessarily the same. Then there's presentation, corpse touching, the idea that the corpse touches when the guilty person, when corpse bleeds when the guilty person touches it. It's very rare, but I've seen it in a couple of cases. So it's intriguing. And then very late on in the prosecutions, we start getting the idea of demonic possession. The witch causes a person to have fits and behaves in strange ways. And you then get really strange versions of malefice coming out. I don't want to spend too long on this, but I do want to give you a kind of overview, because this talk is in some ways quite broad, and an overview of the different kinds of evidence that get used. But the testimony of victims is the big one. Now, evidence for the demonic pact, and I have a sort of impression that this is probably more common and it sends more witches to their deaths. This is evidence that somebody has made a pact with the devil. And the big one is the first one on the list. How do we know that they made a pact with the devil? Well, we asked them and they said. Yeah, okay. So, yeah, we know they're guilty because they've confessed. Sometimes, confession of some other person who has seen them with the devil. You sometimes get long lists of names. Those long lists of names usually get used to then arrest the people being named, and then they get interrogated in their turn. But sometimes you see evidence that somebody else has seen a person at the Sabbath or the meeting with the witch being used to indict a particular person. So the evident testimony of other witches. So, what value does that have? One thing you see quite often is the devil's mark, the idea that when you make the demonic pact, the devil puts a specific mark on your body, which can be identified by pricking with pins, and this is the pin is supposed to go in without causing any pain or without drawing blood. People are sometimes confused about this because there's a lot about torture, and I'll come on to torture in a minute. And people sometimes think that pricking is torture, but technically pricking is different. Torture, as I'm understanding it, as I'm defining it, is pressure of one kind or another put on a suspect to get them to confess, to get them to talk. And pricking is not that. It's intended to produce physical evidence, and it's not supposed to be painful. I mean, the practice might be different, but these are conceptually distinct. Witches can't shed tears. You see this mentioned from time to time. I mean, it's not a thing that's used as a sort of primary piece of evidence, but you sometimes see it tacked on. Witch detectors, from time to time, there's a confessing witch who says, well, yes, I'm guilty, but I have this special power to detect other witches. And this gets used most notoriously in the 1597 panic. Margaret Aitken, the great witch of Balwearie, she says that she can detect other witches by a mark in their eye, and she gets taken around the country by a commission. She may have sent hundreds to their deaths. Nobody knows how many. They just bring people before her, and she goes, yeah, guilty. Eventually, she's discovered to be a fraud, and everyone runs for cover. She's not the only one. A star witness, this is someone who confesses to witchcraft, but is sort of not actually guilty, have not actually made a pact, but they have been to meetings with the devil and with other witches, so they can give a lot of very useful information. Very useful information, yeah. I'm often asked about the swimming test or the water ordeal, and I'm often told, yes, well, of course, they drop witches in the water, and if they floated, they were burnt, and if they they sank, they were drowned. I've had a fiver for every time I've been told that. It's not entirely wrong, it's just mostly wrong. I mean, the first thing to understand is actually early modern folk are not stupid, all right? And this was done sometimes in various countries in Europe. People had a rope tied to them, all right? Nobody drowned. Can we get this clear? Nobody drowned. And most of the people to whom it's done are told that they floated, which the human body naturally does in water anyway. But it is hardly ever used in Scotland. We know it was used in 1597. We don't know on how many, but it's after that, almost never. So we can almost pretty much set the swimming test on one side. But confessions are big. And that is why the Scottish witch hunt is as intense as it is. And so we might want to say one or two words about torture. In the courts that are actually doing this, they do not have any regulations about it. And some continental countries, torture is regulated and it is done in a sort of approved way, and it's all nice and friendly and, well, and let's not get into that. But there really are no regulations for the people who are actually doing it. But they may not have thought it's torture because mostly what they're doing is sleep deprivation. Now, I would say that was torture. And probably most today would say that was torture. And it is pressure to get people to confess. Not only does it make you talk, but it also alters your mental state. You lose confidence in your own memory. You begin to accept the interrogator's suggestions, and you may start to hallucinate, and some weird stuff comes out in those confessions. But because it doesn't cause physical pain, they may have thought it's not torture. And, some perpetrators today, will be also going, no, we don't do torture, we do moderate physical pressure. Yeah. And they don't usually write it down. So we know about it from other sources. And Sir George Mackenzie says torture is common, and I'm pretty sure he's right. And if they write down that a confession is given freely, just occasionally we actually see that, yeah, they first were tortured and then they were asked to confirm their confession later. And if they say yes, well, I give it freely. Yeah. Okay. I now want to go on to how the courts actually process this. And there's what I call the arc of investigation and prosecution. Here it is. And we'll be seeing this quite a lot in the rest of my talk. Perhaps we need some actual courts on this. It begins usually in a local church court. Kirk Session, Presbytery, I'll say more about these. And I just want to do a sketch. The arc. They're the ones at the sharp end. They're the ones talking to the neighbours. They are the ones who see the thing that doesn't look right, or to whom the thing that doesn't look right was reported. But it's not a criminal court. Church court can't execute anyone. So what they have to do is to get authorization from the centre to hold a criminal trial. And they send a delegation to the centre. When the delegation goes to the centre, they are private individuals. When they come back, they are judges, they're trial commissioners. They get a commission of justiciary, and they can set up a local criminal court. And that it will be known as a justice court. And it's sort of not one of the regular courts. It's not a sheriff court. It's not a borough court. It's not any of the regular courts. It's, colloquially, you might call it a pop-up court. It's just constituted to try this one person or these three named people, and then when it's done its business, it vanishes in a puff of smoke. That is how most of Scottish witches are tried. And I'll say more about this in a minute, but I now want to point out some things about the way in which these different courts operate, and adversarial and inquisitorial procedure. Now, I do my best on this. I'm sure some of you understand these things better than I do. But I just want to be sort of schematic about this. And, this is the sort of normal procedure in medieval courts. And the basic idea is that a criminal trial is a contest between the accuser and the accused, and the judge sort of presides, sees fair play. But take the lead. And we see a gradual, whether it's reception of Roman law or whatever, but many courts start to introduce what's called inquisitorial procedure, in which the court does control the process. The court seeks the evidence, seeks the truth. And so let's look at this in a little bit more detail. And I've read many accounts in which they give two lists. There's a list of adversarial and a list of inquisitorial. And I've constructed my own lists because these things are sort of menus that you can select bits, and these are lists that I find useful in analysing the courts that I am actually looking at. So they're not definitive or ultimate lists, but I find them helpful. And I thought I'd start with a third list, which is a list of characteristics that you find in both. And some of it is pretty basic things like a crime is actually a thing. A crime is a specific definite act. They both systems share all of this. It's supposed to be fair. You're supposed to have evidence of some kind, and you're supposed to write it down. But that may enable me to go on more clearly in my next few slides to point out that when you see a thing happening in the adversarial thing, it's a thing that does not happen in the inquisitorial ones. So in the adversarial courts, it is a contest between two parties. And what tends to happen in the courts that keep the adversarial system for their criminal trials is that they start to introduce public prosecution. So that's my thing in brackets there. And so we certainly find this in witchcraft cases, which are almost all prosecuted by the state or the procurator fiscal, if you like. But there's a pre-trial stage, and then there's a trial stage. And the decision of guilty or innocent is made by a jury. That's in the adversarial system, but not the inquisitorial court does not have a jury. A few more adversarial things. You can have lawyers because, lawyers for each side. It emphasizes that there are two sides, and it's a public oral performance. And then some very familiar things like innocent until guilty. These are only in the adversarial system. Okay, and in the inquisitorial system, I can get all this on one slide. The court controls the process, gathers the evidence, seeks the truth. It doesn't really want there to be two different sides because it's looking for the truth wherever it can be found. And they gather evidence gradually. And you don't have to declare anyone innocent. You just sort of say, well, that's all right, we'll let you go. Or we'll let you off with a warning or something. Bit more about the church courts at the first stage. We all be sort of familiar, but just to sort of set it out, we're mainly looking at the Kirk sessions and the presbyteries. So Kirk session in every parish, in the early modern parish, average population will be about 1,000. So if you've got 12 or 20 lay elders, they can get to know the population quite well. They are in touch. If somebody sees something that doesn't look right, the Kirk session may well hear about it. Okay. Sometimes, because witchcraft is a very serious offence, much more serious than most of the stuff that the Kirk session is dealing with, they sometimes pass it up the line to the presbytery, which is the sort of supervising body. Some Kirk sessions deal with it themselves. When you look at witchcraft records in Kirk sessions or in presbyteries, it's often very hard to tell which one it is because they've got the same sorts of procedures. They're an integrated system. The Synod and General Assembly are not usually in the picture. It's something that's done in the localities. So a little bit more about that. This famous painting of an ideal Kirk session. The Kirk session is a disciplinary body, and it's trying to inculcate godliness and punish ungodliness. You can probably see the kind of ungodliness that's been going on here. And the church courts are inquisitorial, okay? There's no jury there. And in fact, it may not even look like a court. I mean, the guy behind the door makes it look as if they don't meet in private, but they do. They meet in private. And they make the decision collectively, and the clerk keeps a written record. So this is a court. I should briefly mention, I think to quote myself, the Kirk Session is not the only show in town. There are some other local courts, and sometimes they are the ones that detect that stuff has been going on. And so sometimes you will see sheriffs or borough bailies, lords of regality, who are doing the stuff at the sharp end. But it's mostly the church courts. So I'll deal with the church courts from now. I now want to move on to the central courts. This is the second stage of the arc. What are the central courts in early modern Scotland? Now, the main one that is doing the stuff at the centre is the Privy Council, which is also a court. It doesn't have the word court in its title, but it is a court. And it's the executive body for the government as a whole. It meets either daily or weekly or bi-weekly or whatever, and it's the top politicians running the government. And that is the usual body that is issuing commissions of justiciary. Some of the other bodies that we have to mention, there's the actual Court of Justiciary, or High Court of Justiciary as it becomes in 1671. Now, this is not a body that issues commissions of justiciary. This is a body that can actually try witchcraft. Because remember, the local courts, maybe I should have stressed this, not only can the church courts not execute witches, but the sheriff court even. I mean, it can execute other criminals, but the sheriff courts almost never execute witches on their own authority. It's recognised to be beyond their competence. They have to go to the Privy Council and get a commission of justiciary to constitute a justice court. But the Court of Justiciary in Edinburgh can try witches, round about 10% of witches. Nobody's got the precise numbers. Get tried in the Edinburgh Court of Justiciary. Another body that, quite surprisingly, issues commissions of justiciary is Parliament. Parliament isn't often in session, but if it is, sometimes we see the local delegates who want a commission of justiciary, instead of going to the Privy Council, if Parliament is in session, they actually go to Parliament, and Parliament does, process individual witchcraft commissions. And in the revolutionary 1640s, the Covenanters supersede the Privy Council and have a thing called the Committee of Estates as their executive body. Does a lot in 1649. But most of the time it's the Privy Council, and it's a very important body. And so let's look at the arc. Here's that slide again. Going from the local to the central court. That's what I particularly want to focus on. How does the local body go to the central body? Well, they are the ones who gather the evidence. So they get witness statements from neighbours, they interrogate the suspect, torture, etc. They get a dossier of evidence. They'll get written evidence, and they will then get some of their friends, local lairds typically, who may actually, in fact, be Kirk Session elders or, ruling elders in the presbytery. Nobody's really done the research to work out, partly because the documentation is quite hard to find, but, how far these are already, in with the bricks of the Presbyterian system. But these local lairds, they want to become the commissioners, they want to be the judges, they want to hold the trial at the third stage. But to do that, they've actually got to go to Edinburgh and they've got to get a commission of justiciary. So they've got to attract the attention of the top legal authorities. And I must admit, I was thinking, how would I do that? Is that the right place to go? I'm not sure. I suspect there may be people in the room who would know about this more than I do, but the point I'm trying to make is that it's it's something that someone from the localities, it might be quite a big step. And here's the Presbytery of Wigton trying to do it in 1706, and they write, this is the covering letter which they write to the Lord Advocate. And what they want is a commission for trial and judging that assigned Jean Brown. They think Jean Brown is a witch. This is one of the cases from the book I showed you earlier, by the way. We hope your concern for the glory of God and suppressing the kingdom of Satan will influence you. So how do you do this? Right, so let's have a diagram. There's the Privy Council. And you're the delegates from the locality, you know, with your dossier of evidence. So how are you going to do this? I think most of the period that we're dealing with, before the 1690s, when Stuart of Gutters takes over, it seems to be not the Lord Advocate that you have to attract the attention of. I think it's the clerk to the council. Evidence for this is fragmentary, but I think this is the person they usually go. He is the guy who controls the agenda for the Privy Council, and he's the one you have to persuade. I've got this dossier, and I need it to be a commission of justice. But in practice, of course, the clerk to the council is a busy man, and he has got a staff. And in fact, it may be one of his servants who are, you know, legally trained people, part of his office that you've got to persuade that your dossier is good enough. And one wonders, the Privy Council doesn't minute its deliberations, so we don't know how they make their decisions. It's a kind of black box, or maybe a red ellipse. But you know, how are decisions made within this group? Hypothetically, you could imagine there's this written dossier of evidence. You could imagine that the servant to the clerk takes the dossier, just says, okay, here's a dossier, gives it to the clerk, and the clerk goes, all right, here's a dossier, put it on the agenda, and then he just puts the entire dossier on the table for in the Holyrood and tells the councillors, is this dossier, read it. Do you think that's likely? Because I don't. I think the servant will read it. I think the clerk might read it. I think some of the Privy Councillors might look through it, but basically they're going to be briefing them, and I can sort of imagine the clerk going, I've got this dossier. Yeah, I've looked at it. It seems to check out. You can have a look at it if you want, but it all seems to check out, so it should be fairly straightforward. This dossier, on the other hand, we've got some problems with that one. I can't prove this, okay, because it's a black box. But what we can see is the decisions coming out. And exactly who briefs who. And it almost doesn't matter in the upshot, because what we're interested in is the decision, excuse me, coming out. And they are really thinking about this, and somebody is reading these dossiers. And you can prove this because when you see the decisions coming out, it's not all the same decision. And here is a list of the things that they can do. One of the things they can do, and it's what the local delegation wants, is that they can actually give them. Okay, your dossier checks out, you want a commission of justiciary. Here's a commission of justiciary, and here's a box of matches in case you need it. There does seem to be a very high conviction rate in those local courts at stage 3. Only a very small proportion of the minutes of the evidence at stage 3 survives, because once the court had vanished in a puff of smoke, it wasn't anybody's job to keep the records. They're supposed to write it down, but from an archival point of view, these things don't have a very high. But from the evidence we've got, there's a very high conviction rate. But that partly is because of what I'm talking about now. There's a filtering process. They only get the commission if the Privy Council goes, yep, this one's going to fly. If they think it's not, they can do other things. We're not going to give you a trial commission. We'll give you a commission to gather evidence and report back. And I think of this as kind of revise and resubmit. Sometimes they do come back, other times they don't. We need more research on these investigate and report back commissions. But you can sometimes say, yeah, we don't think you've got enough evidence yet. They can send it to the Edinburgh High Court. And why they do that, it's hard to tell. As I say, it's about 10% of the cases. I think, it's very hard to prove this, but my intuition is, I can't put it much more strongly than that, is that they're going, yeah, it looks as though there's a case to answer. We need to have a trial, but we need legally trained people to do this. This is a tricky one, okay? And remember, these local lairds, that's what they are. They're local lairds. They don't have, they're property, respectable people, but they don't have legal training. It's unlikely that there are going to be legally trained lawyers in the local court. And so if they want these things done by legally trained people in the Court of Justiciary, even a poor defender, a poor panel is going to have an advocate assigned to them by the court, so they will have it debated properly. And again, this is just intuition, and it's even harder to prove this. I have a sense that there are times when they think, yeah, there's a case to answer, but we don't like the look of you. Your dossier might be all right, but we do not trust you. We do not think you are impartial or, competent to be given a commission. How you prove that is very tricky, but for whatever reason, they have got this option. They usually do seem to be willing to give people commissions, and we could come back to why. But the fact that they do have these alternatives does tell us that they are really thinking about it. And the other option that they've got is that they can actually say, no, you can't have anything at all. And that's what they do to the Presbytery of Wigton, by the way, in 1706. We don't think Jean Brown is a witch at all. And you have not got a case. They don't minute anything when they do that. We don't know how often they refuse those requests. We only ever find out about it when the local delegation comes back to the locality crestfallen. Oh, they wouldn't give us it, and that gets written down, which it is in 1706 in Wigton. But there may be many others that they don't, because the Privy Council doesn't write it down because it's a decision to not do it. To not do anything. It vaguely reminds me of the English procedure of the grand jury, where the grand jury will have conduct a kind of dry run. They look at the prosecution evidence, and if they think the prosecution evidence stands up, they will send it to a trial jury at the assize. If they think the prosecution evidence doesn't stand up, on the spot, the evidence has to be destroyed. So this filtering mechanism is an interesting thing, and I may come back to that if I've got time. Inquisitorial and adversarial procedures. Let's come back to that. Both the first two stages are inquisitorial. Okay, no jury, meet in private, seek the truth. At the third stage, the local criminal court is adversarial. So what does that mean? It's supposed to seek the truth at the first stage. Let's assume that sometimes they do. But, just what if it seeks, if they are shaping it such a way that the criminal court will be able to convict? You could see this as, in these two different procedures as two differently shaped hoops you have to jump through, and it will be extra difficult to get through these two difficult things, these two different things. But, if they really want to do this, if they really want to have convictions, it might be a way that they could actually aim the thing at the target right from the beginning. Not quite sure where I can put these thoughts, but I do. It's something that I notice when I see these two different procedures in operation. Right, just a few more minutes now. During panic periods, things may be slightly different. This is the graph of incidence of witchcraft prosecutions over time, and it is not even, as you can see. Most years, there's just handfuls of cases, or maybe a dozen or so, and then in just a half dozen really short periods, it just goes. Whoop. Let's remind ourselves, this is the art again. In the panic periods, when more witches keep coming up and they think, oh, there's one witch, then there's 3 witches, then there's 10 witches, you can't keep going back to the Privy Council. Instead of giving us a commission to try 1 witch or to try 3 named witches, what they ask for is a general commission. Give us a commission to try all cases of witchcraft, typically for a year, in our locality, in our parish, in our presbytery, in our borough. And when they do that, what happens? They then don't have to go back to the Privy Council again. Once they've got a local general commission, the entire arc disappears. And I want to briefly visit Germany at this point. This may be surprising you, but Scotland is part of a European context, and there are 7 notorious princely states in Germany on the front line of the Counter-Reformation. They're all, there are Protestant states that do this intensely, but these are all Catholic states, and they prosecute witches very intensely, and those 7 principalities rack up over 10% of all Europe's executions. And they do that by appointing special witch commissions. They can arrest, interrogate, try, execute. Procedure just goes straight through, and it's their job to do that. Ellwangen's particularly scary. Once you get arrested and interrogated, they will torture you until you die. You either confess or you die under torture. Those are the only options. That's really serious. And what goes on in those cells in the Bamberg witch prison just doesn't bear thinking about. But the local general commission, it's a miniature version of that. Right. Scotland only has 5% of Europe's witches. But Scotland has only got 1% of Europe's population. So, they're doing it 5 times more intensely than the European average. And it's been set up because the local church court has picked its commissioners, that this system is an integrated thing. They can do what they like. Not much, the general commissions are not very well documented, but I think we need to think about that. Right, so in conclusions, first of all, I want to revisit Brian Levac, who is, I think, Scotland's most influential historian of witchcraft and law. And, he's specialist in Scotland, but he's written about the whole of Europe as well. And he has just done so much to clarify what the Scottish legal procedures are in that chapter, and also in a paper in Stair Society in the Southern Fall in 2002. And this paper on judicial torture was previously given as a Stair Society AGM lecture. These are my written notes, which I took on the 9th of November, 1996, at the Stair Society AGM. So, yeah, distinguished predecessors indeed. I want to sort of build on and respond to Brian Levac. Scotland has a lot of executions, so why? Well, a lot of torture, chain reaction trials. Yeah, we know that. And Levac's take on this is that it's all happening in the localities. The local courts are out of control, and it's a failure of central oversight. I can't help noticing, though, the fact, like most legal historians, spent most of his time at the 3rd stage looking at the criminal court system. But if you look also at the Privy Council, and also in more detail at the church courts, they're also courts. It's all a legal system. Sorry, it just is. They're all courts. And the church courts at the sharp end doing all that torture. To say that they're not overseen from the centre, my goodness, the Presbyterian system is tightly integrated. If the Presbyterian system had wanted to put a stop to unrestricted torture, they could have done. So I think they wanted it. They don't necessarily want unrestricted torture as such, but they want the results. Okay? At least until the final decades. I haven't gone into how this stops. I haven't got time for that. I'm going to have to round up in a minute. And Levac has written very interestingly about that. But let's go back to Sir George Mackenzie for a moment. And Mackenzie didn't like the local commissions of justiciary. This is from his Laws and Customs in Masses Criminal 1678, because he thought that the local lairds, gentlemen, he calls them, are not very good judges. And yeah, it sort of, you get his point, don't you? Yeah. But the council cannot know how these confessions were admitted. Now, come on, Sir George. Come on. They know fine. They just don't ask. And that's how atrocities get committed. Don't tell us the operational details. You got the confession. Yeah, it worked. It just, it justifies whatever you did. Just don't ask. That's what happens. And it's because they want a godly state. And it's not legal. It is not procedural that causes all this. It's because they are committed to a godly state. And I think the fact might even actually agree with that, if you put it in that way. But I hope I've given you some idea about how legal procedures feed into what we might call a miscarriage of justice. We might call it an atrocity. I'm not sure what to call it, but we do need to understand it. So I will stop there. And if you have questions, I'll do my best to answer.
Well, thank you very much indeed for absolutely fascinating talk and insight into the research that you've done, and no doubt there's more to do. But there is ample time, in fact, left for questions. So questions from the floor. Hector.